Weren't you here?
She was just here. I told her.
Oh, okay. So we'll call her again, I guess.
I think she went to bed.
Palmer, do you have your proceeding ready? Paul?
I do. He's on Zoom, Judge.
On the record in the matter of the state of Michigan versus William Joseph Paul, 25-00782, appearance, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of William Hall, who is appearing on Zoom. He was on Zoom. I don't see him at the moment. I just met with him in the breakout.
He's here. Start your video, please. Okay, there you go. Today was the date and time scheduled for a probable cause conference to count one of assault with intent to do great bodily harm less than murder or by strangulation. There is a count 2 of domestic violence, and the matter is scheduled for preliminary examination on April 4th at 8:30. Are we continuing to examine this?
Yes, Your Honor. We are continuing to examine on this matter. There is one other matter, if I could just address it very quickly.
What is it?
Your Honor, the location where the incident is alleged to have taken place, apartment, that apartment belongs to my client. That apartment is on Mount Hope Avenue. My understanding is that the complaining witness, my client was barred from that as a no contact location because of that's where the incident was, and that's where the complaining witness was located at the time. My understanding is that the complaining witness has completely vacated that apartment, no longer resides there. It wasn't ever really her apartment to begin with, but no longer resides there. Also, the apartment complex is my client's place of work. He works for the complex. He is currently wearing a GPS tether that bars him from being there, so he's not allowed to return home or return to work. My request, I guess, would be that the court consider lifting not the no contact order as to the complaining witness, but the no contact order preventing him from returning to his apartment and place of work. He does at the moment have a GPS tether on, which is excluding him from that location. He's obviously being compliant and doesn't want to do that, but he's now been out of work for almost 2 weeks, I think, since the date of his reign.
Let's see here. I think Judge Ward handled this. It does say victim's address, and it gives the same address as him. And that was written by the reigning judge of Sydney Faulkner, I believe, handled this when she did the arraignment. I don't know where she would have gotten that information from the defendant. So she was never living there?
Well, Judge, I guess I'll put it this way. The apartment, sorry. The apartment was in my client's name. He also works for the complex. I think she was sort of staying there, even though she wasn't technically on the lease. I think she was residing there at the time. I think since this incident, obviously there's been a falling out of the relationship, I guess I'll put it that way. They no longer have contact, of course, because of the court's order, but also my understanding is she is essentially whatever items she had there, she has moved out and is gone. So I think it technically she probably was staying there, whether it's however you want to say that.
Does the prosecution have any information?
I have no independent information. My concern is how do we know this? Has Mr. Palmer gone out there and looked at the apartment to see she's moved out? Because obviously the defendant's not going there because he's banned from going to the apartment. He's not having contact with her. So I'm a little curious how we have this information. Is my only question.
Judge, my understanding is that at one point there was some sort of an arrangement wherein my client's, I think, stepmother tried to go to pick up items of his, and she was not there anymore.
Okay, her not being there, though, I don't know that it necessarily equates as she's not staying there. I think I need someone to confirm that through the prosecution's means. And so I'm obviously within now and next week, they should be making some contact with the victim.
Understood.
And then we can figure out with the victim's address. If I can get a valid confirmation that she's not residing at this address, then I'm happy to amend that no contact order to allow him to return to his apartment. The other concern is I have a conflict on the 4th. Did we move this?
No, not yet.
I have a conflict on the 4th. So are you, your client available to do this on the 3rd?
Let me just check. What time on the 3rd?
Is that? Well, what do we have?
Moving PCC to that?
That's fine.
Okay, so yeah, oh, so 8:30.
8:30 on the 3rd?
Yes.
I can certainly do that. Mr. Hall, did you hear that? Or would you be available to come to court on on March 3rd at 8:30 instead of Friday, March 4th? Oh,
April,
I'm sorry, April.
Yeah, I can
April.
do it.
All right, April.
next Thursday.
Yeah, next Thursday instead of next Friday. I'll call you separately to talk about this privately, but I just want to make sure. So April 3rd at 8:30.
Okay.
Yeah. Oh, I'm-
Okay. So we'll note it at this time that we'll continue to do them next week. Any additional matters for today's record?
Not on behalf of the people, Your Honor. Thank you.
None from the defense, Your Honor. Thank you.
Thank you. You're all set for today. See you next week, Mr. Hall.
Thank you.
You're welcome. We have an interpreter on the next one for you, Mr. Palmer.
I'm not aware of an interpreter, Your Honor.
Interpreter's present.
Oh, the interpreter is present. My client's in jail. We're not on the record phone, correct?
Is his client, is Mr. He's not here? I don't know why it keeps doing that. Who's got this, who's got protected information on here? I don't see the anything being posted. So I can release the interpreter for today. To the interpreter, we won't be meeting you today. Thank you for appearing.
Thank you.
Thank you. Let's see, I put, someone was echoing.
Sitting on a case.
Okay, a breakout room. Garza, who's representing, Mr.
I am.
Cornish is representing Garza?
Yeah.
Garza?
No.
I'm on Garza, Judge.
I had to put him in a breakout room because we were getting an echo every time Mr. Palmer spoke for some reason from that. So let's see. You bring him back. And then. Okay. Mr. Garza, can you hear us?
Yes, ma'am.
On the record in the matter of the people of the state of Michigan versus Andrew Lee Garza 25-00253, appearance, please.
Good morning, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish on behalf of Mr. Garza, both appearing via Zoom.
It was the date that was scheduled for a competency hearing. What was in receipt of a report from the Center of Forensic Psychiatry. It was dated prepared March 18th, 2025. Did both parties get a copy of this report?
I did receive a copy, Your Honor. Thank you.
Yes, Your Honor, the defense has received a copy of this report, Your Honor. I have gone over with my client. We're prepared to stipulate to that report for the purposes of today's hearing.
A conclusion of the report opines that Mr. Garza was able to understand the nature and object of the proceedings against him, and that it is the opinion of the examiner that he is competent to stand trial. I got your stipulation to the report, Mr. Cornish. Mr. Martinez, is the prosecution stipulating to the report?
Your Honor, the people will join Mr. Cornish in that stipulation to the report and the findings contained within the report. Thank you.
Will adopt the findings and incorporate it into the court record. An order will be entered deeming Mr. Garza competent, and we will, my understanding is we will be entering an unconditional waiver today. Is that?
But the defense is prepared to waive. I hadn't heard back from the prosecutor's office. I think the prosecutor I've been emailing might be out today.
Your Honor, my understanding is that the defendant is prepared to unconditionally waive the preliminary examination. The people would have no objection to that and would also unconditionally waive their right to a preliminary examination, Judge. Thank you.
Thank you. Okay, Mr. Garza, do you understand that you have the right to have a preliminary examination in this matter because you're being charged with felonies?
You're right.
Do you understand that you have the right to require the prosecutor to present sufficient evidence to establish probable cause as to each felony and probable cause that you committed the felony? Hello, do you hear us?
Yes, Your Honor.
Okay, you want to unconditionally waive your examination?
Yes, Your Honor, that is correct.
Is anybody threatening you to get you to waive your exam?
Your Honor.
Any promises extended to you if you waive your examination? I can't hear you. Say it again.
No.
Okay.
Your Honor.
Okay. Was there an offer on this at all?
Not at this time, Judge. No, we'll negotiate in the circuit court.
Very good. Okay. I find the waiver to be freely and voluntarily made. The matter is bound over for a bind over date of April 9th. That's the date they will get the file from the district court. Mr. Garza does not need to appear in circuit court on that date unless Mr. Cornish is filing a motion for him to be rearranged at circuit court. Looked like there was a no bond on this that will any additional matters for the record.
Nothing additional from the people, Your Honor. Thank you.
Well, nothing from the defense. Thank you, Your Honor.
Thank you. You're all set.
You can just knock on the door and let them know we're done.
Okay, thank you, Your Honor.
Thank you. Can you mute that one? I don't know why there's feedback in
He's been
that.
having problems all morning.
Yeah, we can just mute that one until he, or remove him. Is there, I didn't see the order. Can you get me the order to sign out of here? Thank you. Okay, on the record, in the matter of the people of the state of Michigan versus Jeffrey Clark, 24-03661.
Morning, Your Honor. Randall Berman on behalf of the people.
Mr. Clark, can you hear us? Today was the date scheduled for, thank you. Today was the date scheduled for preliminary examination, I'm sorry, for probable cause conference for possession of methamphetamine. It's scheduled for preliminary examination on the 4th of April at 8:30. My understanding is that there's an unconditional waiver on this.
That is my understanding as well, Your Honor. Thank you. Randall Berman on behalf of the people. It's my understanding the defendant wishes to unconditionally waive his right to a preliminary examinations with negotiations that continue in circuit court. The people also waive unconditionally their right to have a preliminary examination of the matter. Thank you.
Ms. March.
That's what, my client, we discussed the matter and that's what he wants.
Mr. Clark, you understand your right to have a preliminary examination in this felony file?
Yes, Your Honor.
You understand the purpose is so that the prosecution would have to first establish sufficient probable cause that the felony was committed, and then probable cause sufficient to charge you with the felony. You understand that purpose?
Yes, Your Honor.
You wish to unconditionally waive your examination?
Yes, Your Honor.
Can you say that again so I can hear you?
Yes, Your Honor.
Is anyone threatening you to do that?
No, ma'am.
Has there been any promises extended to you to get you to waive your exam?
No, Your Honor.
Signed over date is April 9th. That's the date the circuit court's gonna get the file from the district court, not a date that you need to appear in the circuit court, okay?
Yes, Your Honor.
Your next court date will be a pretrial in circuit court. Your attorney will be made aware of that date. Do you have any questions at this time?
No, Your Honor.
You said negotiations will continue at circuit court.
Yes, Your Honor.
He was remanded, I believe, after failure to appear. Are we requesting bond at this time?
Yes, Your Honor. If I may address that.
You may.
Mr. Clark has some serious health issues. He told me that the reason why he didn't show last time is because he was at the hospital. It's my understanding that he is in need of some major surgery affecting his heart. So we will respectfully ask the court to give him a PR bond, understanding that this is for his health. So that he is able to get to the doctor, that he don't have to come to court.
Did you want to address the bond motion?
I did, Your Honor. From what I can see, it looks like he's got no bond on this case from this court, and I certainly don't object to the court granting a bond. Now, I don't know that PR is the responsible way to go. For this reason, he also has a possession of methamphetamine pending in 55th District Court. That file, according to the jail's website, has a $10,000 cash surety bond. So if you grant the PR, he effectively quits getting credit on this until he posts that $10,000. And then on top of that, he also appears to have a hold from the Michigan State Police with a $674 bond. So I think giving a PR bond is foolhardy at this point, because he would, number one, has a history of failure to appear. Number two, has 2 possession of meth cases pending. And then number three, he has for his time served while he's waiting to post bond on the other. So for that reason, I don't oppose a bond being given. I just think PR is not the way to go. If the court is interested in a lower or PR bond, I request some kind of tether that will monitor the defendant's whereabouts in the very least, and also random and frequent testing.
Okay, I think I originally arranged Mr. Clark. I think I had already ordered testing 1 time a week, which obviously has not been happening, or was not happening. I noted even at the time that I think he was a cardiac patient. The concern that I have is that Mr. Clark failed to appear December 26th and for the PCC, then failed to appear again January 2nd. And we didn't see him again until March, and not because he turned himself in. And his excuse to the magistrate was not that he was in the hospital during those times and unable to appear. To be clear, we get people that are in the hospital often, they make sure that the court is advised that they're missing their court date because they're in the hospital. That's not what happened here. He did say he might have been in the hospital, but he wasn't in the hospital when he was picked up on this warrant. So even if he was in the hospital, he had a responsibility to get himself after being released. He did not do that. He has very serious charges pending, not just in this court, but another court. I will issue a bond with GPS tether to the extent that he's able to post his bond in 55th. His bond in this matter will be set at $2,000 cash surety with GPS tether. All previous bond conditions will continue, and that includes testing 1 time per week. Any additional matters for the record?
Not on behalf of the people. Thank you.
Not for the question.
Thank you. You're all set for today, sir.
Thank you.
Thank you. Mr. Clark, you can let them know that you're all set. You can knock on the door. This is the matter of the state of Michigan versus Tyrance Stucky. 25-00798. Appearance, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Stucky, who joins us on the Polycom from the Hingham County Jail today.
You can remove Mr. Clark. Mr. Stucky, can you hear us?
Yes, ma'am.
Okay, today was the date set for a probable cause conference for count 1, assault with a dangerous weapon, felonious assault. And there's a count 2 of a domestic violence, and a count 3 weapons, felony firearm. Matter is scheduled for preliminary examination next week, April 4th at 8:30. Were we continuing to examine?
Yes, Your Honor, that is correct.
Okay, I have a PA 53 violation here that he needs to be arraigned on. There's a complaint of violation of conditional release. Mr. Stucky was arraigned by Magistrate Milmore back on March 17th. He indicated that he's not to have contact directly or indirectly with Kira Ann Gonzalez, the supposed victim in this matter. However, the violation alleges that he's violated the no contact order by having contact with the victim, called and spoke to her 9 times between the time of March 17th and March 20th. While in the Ingham County Jail on a recorded line. And so there's a report. Did you get a copy of the report, counsel?
I'm looking right now, Your Honor, and
It appears I've got something in here, but it wasn't. It wasn't on my schedule, but it actually been filed. I just had a report.
Okay. Okay, so Mr. Stucky, let me advise you that you've been accused of violating your bond 9 times from the Ingham County Jail. You have the right to have a contested hearing on those violations and the right to be represented by your attorney at that hearing. Violating your bond is a contempt of court proceeding, and if you're found to be guilty of that, you are subject to a penalty of 93 days per violation. Do you understand that?
Yes, I do, Your Honor. But I only called my.
Hey, stop.
I think your attorney is telling you to stop. I'm going to remind you of your right to remain silent because anything you say can be used against you. I'm going to enter a not guilty plea on your behalf at this time. This matter will be set for a PA 53 hearing. Due to my schedule and the new additional charges, I'm finding good cause to go beyond the 21 days. I'm resetting this for PA 53 and a.
She said it on April 4th. You want me to move it? I know. You want me to move it to the 3rd, or you want me to move it to the exam?
I'm gonna be on 21 days. I'm resetting everything. That's what I was just saying. I'm finding good cause to go beyond the 21 days to have this matter set after April 4th. Okay, what's the new date? May 1st at 9 a.m. for both. Mr. Stucky, do you have any questions for the court?
I don't even know what to say, so I just, my attorney will speak for me because everything I seem to say gets me in trouble and I don't know what to do.
Okay, you should talk to your attorney in private. I don't know if you have any questions for the court. However,
I only have one thing though. I've been here for 2 weeks and I've been asking for medical attention because I was dealing with problems before I got here and no one has addressed anything that I asked of. And I have a serious
you're
condition
seeking medical
going on.
attention for what?
I have MRSA. Look at my face. My face is blown out. I've been asking and asking. I've seen other inmates come in here. They've seen the nurse or whatever. No one is addressing anything I asked.
You submitted a kite for medical assistance?
Yes, I did, ma'am. Yes, I did. As soon as I got here. Because this is something I was dealing with before I came here.
Okay, that's an issue your attorney should be helping you resolve. The court's doesn't go to the jail to make sure you get your kites responded to. However, if there is a kite, your attorney can contact the jail to follow up on it.
I will do that now that I'm aware of this, Your Honor. Thank you.
Do you have any other questions for the court?
So when's the soonest, so I gotta do another month in jail?
You don't have to do any months in jail. You can post bond and then you don't have to sit in jail. There was a bond on this.
I mean, but it was a 50,000 cash assured.
That's due to the nature of the offenses and the risk of flight. So you can post the bond, you get a bondsman, and then you don't have to sit in jail for next month, okay?
I don't have $50,000.
Additional matters for the record?
Then I would just propose that the court, if it could, send notice to the jail that the defendant's jail, phone privileges should be suspended until such time as we get back to court. It's quite a amount of time before we're back in court, and I understand the reason for that. However, it appears as though at least we have a little bit of evidence here from what I've read in the report about what is contained in those phone calls about the defendant telling the victim what to say and saying things were worded wrong and you need to tell him this, that, and the other, that his phone privileges should be suspended except for phone calls with his attorney. Obviously, he needs contact with them, but I think at this point in time, it might be best to have that happen.
Okay, your request is granted. His privileges will be revoked for calls and video visits except to his attorney.
Thank you, Your Honor.
Thank you.
Excuse me.
Yes.
I need to speak to my attorney because I only call my phone.
Okay,
Stop.
you can speak to your attorney.
I didn't
You
call
can,
the
you
defendant.
can speak to your attorney. It will not be in the middle of the court, though. She'll make arrangements to speak to you privately. Okay.
What I'm saying is, if it's shown that I only call my phone and
Mr.
my
Stucky.
phone privilege is gonna be
Stucky, please
given
stop.
back to me, I have no family in Michigan.
Yeah.
You talk to your attorney. Talk to your attorney off the record. We'll address this at your hearing. You're all set. You can let the deputies know you're done for today.
Thank you, Your Honor.
Thank you. Vincent Flores. On the record in the matter of the people of the state of Michigan versus Vincent Flores 24-00097. You can remove him if you have it. Council appearance.
Thank you, Your Honor. Randall Berman on behalf of the people.
I'm sorry, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Vincent Flores, who is, I think, appearing from Maine County Jail. He's in jail, I know for sure.
Okay, Mr. Flores, can you hear us? We can't hear you.
Yes.
Okay, today was the date scheduled for a probable cause conference. We have one count of weapons, dangerous possession, and it says here this matter was scheduled for preliminary examination on the 4th of April at 9 a.m. Are we continuing to examine?
Your Honor, that's the intention right now, although Mr. Behrman has just conveyed to me a misdemeanor offer. I will need to talk to my client about it. There is certainly a possibility that this may result in a plea as opposed to an exam. I will also note that Mr. Flores is being held on another matter. He had a case in which he pled before this court, failed to appear for sentencing. He has been remanded pending sentencing. Sentencing is not until May 30th, I believe.
Okay, so I will have this matter reset for the 3rd of April. And that'll give you time to talk to him and determine if we're going to have an exam or a plea.
Absolutely, Your Honor. I will certainly talk to my client well in advance. Obviously my attempt or my hope is I can contact the prosecutor and call off witnesses. If that's what's gonna happen.
Sounds good. We'll just find out which prosecutor it should be, I suppose.
Well, I'll call Mr. Behrman no matter what.
Okay. Sounds good.
Sounds good to me, Judge. Thank you.
Okay, thank you.
Thank you, Judge.
No problem. Do you have any questions today, Mr. Flores?
Oh, yeah.
Okay, you're all set. Thank you.
Just to clear, said the 3rd, but at 8:30.
Oh, what time on the 3rd? 9:30.
What's that?
We'll see you next week on the 3rd at 9:30.
Okay, thank you.
You're welcome.
Okay.
Is Caleb Ray here?
Yes.
Yes, ma'am.
On Zoom. Thank you. You can start your video, sir. You can remove the jail. On the record in the matter of the people of the state of Michigan versus Caleb Jaquan Ray, 25-00803, appearance, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
And good morning, Your Honor, Assistant Public Defender Aaron Schroeder on behalf of Mr. Ray. I am here in the courtroom. Mr. Ray appears via Zoom this morning.
Okay, Mr. Ray, you are scheduled for a probable cause conference today for an assault with a dangerous weapon, a felony firearm, and a police officer assault, and there's a domestic violence. The matter is scheduled for a preliminary examination on April 4th at 8:30. How are we proceeding?
Thank you, Your Honor. At this time, we would be, the defense would be asking this matter be left set for preliminary exam. Prosecutor and I are continuing our discussions as to this matter, but we will be ready to proceed on that day. Thank you.
Okay, I have a conflict with that date. However, I'm not sure how it affects subpoena. He's not in custody, so I have no problem finding good cause to go beyond the 21 days.
So I have no problem getting subpoenas out on cases today, try to get them served within the week, but the least amount of those that we have to do, I think would be wise. So if he's out of custody, I guess, assuming the defense is okay with that, I would request a little bit more time for that. I'm gonna have to scramble to get this done.
If the court is, if the court's going to find good cause, then I don't really think I have much to say about the matter. Thank you.
I won't be here.
I understand.
Okay, so, Mr. Ray, you have the right to have your examination within 21 days of the date that you're arraigned. Due to the court's schedule, I am going to find good cause to go beyond the 21 days because I need to reset this matter, okay?
Yes, ma'am.
May 1st at 8:30.
Your exam will now be May 1st at 8:30.
First at 8:30. Okay.
Do you have any questions for the court at this time?
No, ma'am.
Bond was set at 15,000, 10% with GPS tether, not to be within 2,000 feet of the alleged victim and not to have contact directly or indirectly with the victim. That will continue. Any additional matters for the record?
Not on behalf of the people, Your Honor. Thank you.
On behalf of the defense, thank you.
You're all set, Mr. Ray.
Thank
You're welcome. Is Willie Cole here?
We'll look for him right now.
No. I wanted to take one last look in the hallway, if I may, Your Honor.
Mr. Palmer,
Yes, ma'am.
James Smith,
Yes, ma'am. Yes.
on the record in the matter of this state of Michigan versus James Rashard Smith, 25-00844, appearance.
Morning, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Robert Palmer of the Public Defender's Office on behalf of James Smith, who appears today via Zoom.
Can you hear us, Mr. Smith?
Yes.
Okay, today was the date scheduled for a PCC for count 1 unlawful imprisonment, count 2 unlawful imprisonment, count 3 assault with intent to do great bodily harm, less than murder or by strangulation, count 4 same assault with intent to do great bodily harm, less than murder or by strangulation. There's count 6 of domestic violence, and this is charged with habitual offender second offense notice. we have a preliminary examination scheduled April 4th at 9 a.m. Are we continuing to exam?
Yes, Your Honor, that's our intention at this time. I know the court probably has conflict with the date, so
Okay.
we're prepared to move it.
Thank you. Mr. Smith, you have the right to have your exam within 21 days of the date that you're arraigned unless you waive the 21 days or the court finds good cause. Due to my schedule, I'm finding good cause to go beyond 21 days so that this matter can be reset, okay?
Okay.
May 1st at 8:30.
May 1st at 8:30 is your new exam in person at the court.
Okay. Thank you.
Thank you. Do you have any questions at this time?
No, ma'am.
The bond was set at 7,500, 10%. There's a no contact order. You're not to have contact directly or indirectly with the victim in this matter. That you're not to be within 2,000 feet of wherever the victim is. That bond will continue. Any additional matters for the record?
Not on behalf of people. Your Honor. Thank you.
No, Your Honor, thank you.
We'll see you on May 1st in person, sir.
Thank you.
You're welcome. Will the state of Michigan versus Rashard Glass, 25-00854. Appearance, please.
Good morning, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Public Defender Office, on behalf of Mr. Glass, who is standing to my right.
Mr. Glass has a probable cause conference scheduled today for count 1, controlled substance delivery manufacturer. And count 2, weapons, firearms, short barrel, shotgun rifle. Count 3, felon firearm. Count 6, controlled substance maintaining a drug house. And there's an habitual offender second offended notice. This is scheduled for exam next week, April 4th at 9 a.m. Are we continuing?
Yes, Your Honor, thank you.
So at this point, you know what I'm gonna do, correct?
Yes, Judge.
Sir, I've got to reset your matter due to my schedule, so you have the right to have your exam within 21 days. Unless you waive the 21 days or the court finds good cause, I will find good cause to go beyond the 21 days and reset this matter, okay? Do you have any questions?
May 1st at 9 a.m.
May 1st at 9 a.m.
My thanks to the court.
Thank you. Do you have any questions today?
No, Your Honor.
Bond 7,500, 10% will continue. Any additional matters for the record?
Not on behalf of people, Your Honor. Thank you.
Not for the defense either, Your Honor.
Thank you. Thank you. Look at that, wonderful. Congratulations. I can run it. No, they didn't put Ronnie Williams on. Assuming Cole's not here.
No, unfortunately not, Your Honor.
Sheriff Trent.
Court needs to go on the record for Kohler.
No, I'm just gonna show Trent.
Okay, thank you, Your Honor. Thank you.
No problem. And then we have Mark Rogers present.
Yes.
Okay. I don't know what this says. Who wrote this? 17.5 prior, I think.
Yeah.
Who represents him?
Me, Your
Oh,
Honor.
okay. I don't really know what this, like, who was supposed to do something with this file, it's just a blue sticky note, 17 fire, I don't know if this is old from 2016, I don't know. I have no idea.
Yeah. You need it?
Am I gonna be asked any questions?
I don't think so. I'll double check.
This is for Mr. Rogers? What are we talking about?
Yes.
Yeah, I see where he was sentenced to 180 days. At the time, and he had credit for 5 days, 75 days to be suspended upon payment of fines and costs. I don't see any restitution on here. And it was Judge Clark, so we know that the fines and costs were maxed out.
Right.
Oh, we talked,
The most important thing. And then, so he was set, we just found him here in jail or?
I don't have.
I think it was supposed to,
I have Ronnie Williams. Oh.
Mark Rogers, that's what I'm talking. Okay. Yeah, Rogers was supposed to 180 days credit for 575 of those days will be suspended upon payment of fines and costs. So obviously he was supposed to serve the remaining and then he was never seen again. That's what it appears. Can I have an updated criminal history? You say you have Ronnie Williams?
I do, Your Honor. I would need a few minutes to speak with him. I did not realize he was still in custody. I thought he was.
He's downstairs. Is that what
Yes,
you're
I
saying?
did not realize that it wasn't updated in our system.
Sounds good.
I apologize.
Mr. Cradaville is here for a bench trial. Is Teresa Scott here? Well, sounds like the matter will be dismissed.
Is that on,
This is a civil matter.
oh, well, so there is also a counter.
Okay, well, I may pull the file up.
It was a one-piece train. It was an old refrigerator. Right.
Okay, her claim is dismissed and your counterclaim is granted by default.
All right, I have it.
Yes.
Would you like me to sign that?
matter. I know it's gonna be e-filed.
Yes, sign it, because I'm gonna sign it and then we'll scan it in. Yes.
Dismissal, Your Honor, or is it working entry or something?
Well, they'll print one for me, thank you. And I can get you a copy of this.
It'll be filed on the system, right? I'll get an email, I think.
Through my file,
Yes.
suppose, I don't know how it works on the other end.
We usually get one in the mail and one
Okay.
via email, so I'm comfortable with that too.
That's fine, if you don't wanna wait, that's good.
Thank you so much.
Thank you.
Oh, yeah. I don't know.
Yeah, I said I have it.
It's not much different.
Right. Yeah.
It's just. But it says it's not good.
On the record, in the matter of the people of the state of Michigan versus Mark Rogers in file number 15-03544. Yes, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
Jacob Riley on behalf of Mr. Rogers.
Mr. Rogers. For sentencing. Resentencing, I should say. He was before Judge Clark on a sentencing back on October 2nd, 2015. So he's supposed to appear. He was before Judge Clark on August 14th, 2015, to which he was sentenced. Whatever's here looks different than what's on the judgment of sentence. It says in the file, 1 year or $2,000. Oh, let's see. That's what he pled guilty to. Looks like he was supposed to appear for sentencing. Okay. He failed to appear for sentencing on the October 2nd, 2015. And we didn't see him again until February 12th, 2025. He was supposed to report to probation by March 28th at 9. That didn't happen. I revoked his bond, and then he logged into my Zoom this week, and we told him he needs to get to probation the same day if he wanted the bench warrant quashed. He did, and so that leaves us here. There was a judgment of sentence prepared, but it just was not ever executed, and that's because Mr. Rogers failed to appear for that sentencing. And I now have an updated criminal history because obviously you didn't get to probation enough time for them to actually do a meaningful investigation or report.
Early this week, you mean, Your Honor?
Correct.
Yeah, she scheduled a date for me to come in. I believe, yeah, April 4th.
Interesting.
Yeah.
Okay, and so I reviewed your prior criminal history. It looks like you had stayed out of some level of interaction with the criminal justice department until recently. So you just picked up a new charge, is what it looks like.
Your Honor, I believe that it's actually from the incident back in 2015, the pending case.
Charges, yeah.
I have here, February 11, 2025. He was arrested on a misdemeanor larceny, which is the same day he was arraigned on this bench warrant.
Well, he does.
That's how he didn't turn himself on this bench warrant.
Right, not that he turned himself in, but just to say that I believe that larceny is from back in.
Yeah, no new cases.
Okay, so you didn't, so how did you get picked up on the warrant?
Oh, I was riding my bike and I got stopped.
Okay.
The officer was curious about the electric bike I was riding.
Okay, I don't want to hear about that situation.
Okay.
Just want to know if you turned yourself in. Why, where have you been for 10 years?
I was in Indiana. I have children there, and so that's kind of part of like how it got stuck down there.
So you knew you had sentencing and you just said, no, I'm just gonna go to Indiana.
No, it was a case of that when I was in Indiana, like I was telling the lawyer, I was dealing with child support and I got incarcerated there.
For 10 years?
No, Your Honor. But it was a case that went from 19 to almost 24.
I don't know what you mean, from 2019?
Yes, ma'am.
You're supposed to be here in 2015.
Yes.
Where were you in 2015?
I was in Indiana.
Why were you not here for your sentencing?
I was doing court days back and forth, Your Honor, with Indiana as far as the child support. That's what I was telling.
Why were you not here for your sentencing? Well, I don't care that you got another case going. What's that got to do with why you didn't come for your sentencing?
Yeah, Your Honor, at the time, I was, like I said, I was trying to take care of my children and deal with the child support stuff down there in Indiana. I take responsibility for not showing up for my court date, Your Honor. I'm not trying to get around that.
So you weren't being held in 2015 in jail, correct?
Not the, not the whole
So
year.
you just decided you weren't coming to court here for your sentencing, correct?
No, Your Honor,
So what happened? Why didn't you come?
I was in Indiana at the time dealing with that situation, and I told them that I had, the court here in Michigan, but I went to jail there.
You didn't go to jail in 2015.
That's what I was explaining to the attorney, Your Honor. As far as I remember, I was in Indiana, I got picked up on the child support warrant.
Yes, but you
Right.
didn't go in 2015 to jail.
It was like 2015, I believe.
You just finished telling me it was 2019.
That was a different time, Your Honor. I'm just speaking on 2015.
Okay, so you went to jail in Indiana in 2015. Where in Indiana?
Lafayette.
Okay, so and how long were you in jail?
Remember, I was there, I don't know, a few months.
Okay, when you got out, why didn't you come report to this court?
I didn't have any, I lost everything, Your Honor.
Lost what?
As far as, possessions and jobs, and I just was broke. I was trying to get back on my feet in Indiana to come back this way. Like I said, I take responsibility, Your Honor. It was a lot going on as far as the children and stuff, and
why do you keep talking about a lot going on as far as the children and stuff? It sounds like you weren't taking care of your children if you had a child support issue going on.
yeah, I was trying to do my best.
Okay, you can make allocution, Mr. Raleigh.
Mr. Rogers has been saying this was 10 years ago. I think he certainly is very different today than he was then. He is employed. He does have stable housing. Certainly well past his days of any kind of mischief or crime, including larceny. And he has made efforts to get current with child support and take care of his children. In those regards, I think certainly he has improved as a person, and I don't think he's a risk to the community at this point. The sentencing to the court's discretion.
Where do you work?
A Rio Town Clubhouse. Chef.
For how long?
2.5, about 2.5 months, 3 months.
Your fine is $250. What are you gonna pay?
I have 30 days, Your Honor.
How much you gonna pay in 30 days, the full amount?
Yes, ma'am.
We'll come up to make payment at the criminal traffic window and he'll be all set. So he has a pretrial on another matter now?
Yes, that larceny from 2015 is scheduled for pre-trial. Well, it was scheduled on the 24th. It's been rescheduled at this point.
I may, Your Honor, that's why I came or called, because I had the Zoom meeting for the 24th on that case, and then I came in, but yes, it's back from 2015 as well, I guess.
This larceny. What, it was the 24th?
Yeah, he didn't.
He didn't appear. I reset it already?
No, I don't think he ever made the file after the big one was done.
Oh, we need the file. I don't think we ever reset it after that Bishmore was done. I need that file.
We can't find it. We've been looking for it. I've sent emails to
Well,
everyone.
it doesn't sound like anything happened. They can just create a new one, can't they?
I don't think so.
It didn't sound like anything happened, except for an arraignment. You can have a seat while we figure out a file, so we can get the pretrial on that one reset.
Right.
Oh, that's right.
It's more cute. Yes, I don't know. So. But it's still interesting. Prada. Or in the bike can't go over to you. Sure. But they don't have.
Oh, I got a film request for Brian Ring.
They don't have the offset here. Well, yeah, you know, you don't want to be on the road where the traffic's 40, 45. Oh, no. No, sir. No, sir. Yeah, if you do off throttle, they say 50. Because it's two 48-volt batteries. And I thought they worked together, but it seems like you can run it off in just one. Say, yeah. Yeah. Oh, yeah. Well, I'm young. I'm trying to get my license back as well. So it was perfect. Actually, with the word insurance, just cold outside. You better be ready. Yeah. Stop me, he said. Headlight at the time was messing with headlight because it's like that hard push plastic like this. It's like how fast does it go? He said, he told me like they don't have any bars. Specifically. Like, they got out of the but she's on your line. You know, they ride bikes year round. Definitely $2,000. Oh yeah. No, I don't have to. Well, I mean, you don't have to. Like, so we can leave it on, but probably still not. Yeah. They can't ride it. They can pick it up. It seems like that's why the weather will not break. Can't be walking. Yeah, yes, exactly. Wouldn't believe the difference. Issues. Weather change. You know what I mean? Like, so mild.
Or pre-trial date.
April 14th.
At what time?
10.
April 14th at 10 is gonna be your pre-trial on the other matter.
April 14th, 10 a.m., Your Honor.
That's correct.
Yeah. Yes, sir.
You have any questions at this time?
No, Your Honor.
All set, we'll get you a notice though.
Okay, thank you.
You're welcome.